Always.
Right, if someone had just admitted on a Samsung device, could you unmute your device and let me know your name, please?
Christopher Webb.
All right, Mr. Webb. All right, your attorney is John Glazier, correct?
Yes, Your Honor.
All right, I am going to put his initials after your name.
Okay.
And then I'm going to put you in the waiting room. Mr. Glazier goes to Judge Olsaver first and then comes down to me. So it might be about, it could be up to 30 minutes, okay?
Okay, sounds good.
All right, thank you. All right, I have a gentleman joining me from the MDOC. What is your name, please? I know who he is, but...
He's on the second page.
Yeah, but he doesn't seem to hear me, Stinson. Yeah. Mr. Stinson, can you hear me? No? Mr. Stinson, wave your hand if you can hear me. I don't even know what to do about that because if he can't hear me, he can't see the chat messages. So, all right. Let's see. And when Stewart. Come on, I really got John Glazier. I never get him that quick. Mr. Glazier, you're making a liar out of me. I told Mr. Webb you go to Judge Olsaver first, but it came to me first. Yeah. So I've got Christopher Webb if you're ready on him.
Sure, I'm ready.
All right. Mr. Where'd he go? Mr. Webb, go ahead and unmute your device and start your audio.
Okay.
I lied to you because Mr. Glazier came to me first. So this is in the matter of the people of the state of Michigan versus Christopher Webb. I have John Glazier appearing on behalf of Mr. Webb, and Mr. Webb is appearing via Zoom, and I have Isaac Sneed appearing on behalf of the people. This is the date and time set for a pre-trial conference. Mr. Glazier, how do you wish to proceed on behalf of Mr. Webb?
I need to speak with Mr. Webb for a moment, Your Honor.
All right, I'll give you a moment. Mr. Webb, you're going to get an invitation to join a breakout room.
Okay.
Where'd you go? There you are. And go ahead and join it.
Okay, there we go.
All right, Mr. Stinson, can you hear me now? All right. Go tell them. Mr. Stewart, I brought you in. I just wanted to add your attorney's initials. after your name, so that way, when your attorney gets here, I know that you're his client and I can bring you back in. So I'm putting his initials after your name, and then I'm gonna put you back in the waiting room. Brian Fry, I have Mr. Stinson, but he does not appear to have audio of us. He's gone a couple times to get assistance. So we're hoping that that works. Mr. Nine, I brought you in. I'm going to rename you by adding your attorney's initials after your name so that when she gets here, I'll be able to bring you back in, okay?
Okay, thank you, Your Honor.
Thank you. Wait just a minute, Mr. Smith, I'm just getting organized. Brittany Foor, I have Brian Fry. So, Mr. Fry, are you with me? All right, Ms. Foor, I'm gonna pop you in the waiting room and I'll be right with you.
Okay.
All right, can you hear me from MDOC? MDOC? No. Even chat with them. They're on a Polycom. I can't hear you.
He's on the phone with somebody.
Yeah, okay. I'm gonna close that breakout room. All right, Brittany, I'm just gonna put you in the waiting room and I'll bring you back in. All right, I have, where'd he go? Christopher Webb back. So, Mr. Glazier, how would you like to proceed with Mr. Webb?
Yeah, excuse me. Your Honor, Mr. Webb is going to plead guilty to an added count of possession of cocaine with a Killebrew agreement to no upfront jail, with the understanding that the charge of possession of meth and the supplement would be dismissed at the time of sentencing.
Mr. Sneed, is that a correct recitation of the plea?
Yeah, Ms. McClure had added the condition that he's completing programming at Boyne and New Vision.
Yeah,
I don't know the present status of that.
Yeah, he's in, what are you doing?
I'm in residential treatment. Not residential, I'm so sorry. I'm in transitional housing with Home and New Vision. So that was Boyne Falls I've completed. That was inpatient treatment, and I'm now in outpatient, and I'm in transitional housing. I currently just started an employment, so everything is going very well.
Good news. All right, so other than that, Mr. Sneed, anything else?
No, just say, hey, Chris.
Hey, how you doing, Isaac?
All right, man.
They're here, it sounds like.
Okay, can you hear us now with MDOC?
I don't need to click pound. Okay. Hello.
Dude, we can hear you.
All right, sounds, yeah, we can hear you. Sorry about that.
Oh, you can hear us now with Mr. Stinson?
Yep. All right,
Okay,
bye.
great. All right, thank you. All right,
Share with
okay,
others.
we'll be with you in just a second, Mr. Stinson, okay?
Yep.
Okay, great. So, Mr. Webb, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Now, Mr. Webb, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to an added count 3 possession of cocaine, which carries a maximum penalty of up to 4 years in prison with a Killebrew agreement, that there would be no upfront jail, and obviously that you continue in your programming, and it sounds like you completed most of it. So is that your understanding of the plea?
Yes, Your Honor.
And you intend to plead guilty to that count?
I do.
All right, are you satisfied with Mr. Glazier as your attorney and the advice that he has given you? All
Yes, Your Honor, I am.
All right, and neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court other than the Killebrew agreement. Is that correct, Mr. Glazier? You're muted, Mr. Glazier.
That's correct, Your Honor.
All right, Mr. Sneed.
Yes, Your Honor.
As far as you're aware, is that correct, Mr. Webb?
Yes, Your Honor.
All right, so if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Mr. Webb, do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Webb?
Yes, Your Honor, I do.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor, I do.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation. Hold on, I'm looking. I just had Miss Walsh and Mr. Moore pop in. Exclusion from admission to the United States of America or denial of naturalization. Do you have any questions about the rights that I've given to you, Mr. Webb?
No, Your Honor, I do not.
All right, so Mr. Webb, how do you wish to plead to the charge that on or about October 11 of 2022 in the city of Adrian in the county of Lenawee, that you did commit the added offense of count 3, possession of cocaine less than 25 grams? Guilty or not guilty?
Guilty.
All right. Has anyone made any threats or promises to you to induce you to plead guilty to this charge? No. Yes or no?
No.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor, I do.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Glazier?
No, Your Honor.
Mr. Sneed?
Oh, Your Honor.
All right. Has your attorney, other than the agreement that was placed on the record, promised you any particular sentence or estimated what your sentence will be?
No, Your Honor.
Is it your own choice to plead guilty?
Yes.
So, Mr. Webb, on October 11th of 2022, were you in the city of Adrian in the county of Lenawee?
I was.
And at that time, did you have in your possession, for purposes of the plea, cocaine?
Yes, Your Honor.
Okay. And did you have any legal right to possess that?
No, Your Honor.
All right. And you knew what it was?
Yes, Your Honor.
All right. Would you agree it was under 25 grams?
Yes, Your Honor.
All right. Mr. Sneed, are you satisfied?
I am, thanks.
All right. Has the court complied with MCR 6.302 B, C, and D? Mr. Glazier?
Yes, Your Honor.
And Mr. Sneed?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Glazier, are you available on May 29?
Yes, I am.
And Mr. Webb, you have a right to appear in person for sentencing, or you can appear via Zoom. Do you want to appear in person or via Zoom?
Due to my employment situation, I would like to appear in Zoom.
Okay, very good. So I will put that down as a Zoom sentencing. I'm going to put you in a breakout room with the probation officer. I don't know which one yet because they got to turn their camera on. They're going to give you instructions. You are going to have to meet with them and they'll talk to you about how to do that. And then when you meet with them, be truthful about your background, the events that occurred, also any addiction issues that you have. They'll prepare a pre-sentence report. We will provide that to Mr. Glazier. He will review that with you before the day of sentencing. So make sure you reach out to him at least a week before. And we will see you back here via Zoom on May 29 at 8:15 in the morning. So Ms. Walsh, I am going to put you and Mr. Webb into a breakout room, and it'll only take a few minutes, Mr. Webb, and we'll see you back on that day. Thank you.
Thank you so much.
Okay, so hold on, Mr. Glazier. I have one more for you. I did. All right,
Bonica,
Mr. Glazier, I don't have, yeah, he's at 9:30, right? No? Yeah, Bonica's at 9:30.
it is. I have it in person, but I could do it by Zoom if you want to get him on Zoom.
He has to be in person, so
Okay,
I think,
I'll be down there at 9:30 then.
okay, thank you. Okay, Mr. Fry is in my Zoom room, but he's not responding, so hold on a minute. Okay, Mr. Fry, we're looking like a legal beagle today, I see.
Yeah. Sorry, Your Honor.
Okay, let me get Mr. Stinson's file. So in the matter of the people of the state of Michigan versus Devonte Stinson, file number 25-22218FH. Mr. Stinson, just to verify, you can't hear us now, is that correct?
Yes, ma'am.
All right, good. So this is the date and time set for arraignment in this matter. I have Brian Fry appearing on behalf of Mr. Stinson and Isaac Sneed appearing on behalf of the people. Mr. Fry, you waive the reading of the felony information.
Yes, Your Honor.
All right, have you received a copy of the prosecutor's request for discovery and witness list?
Yes, Your Honor, as well as the
All right.
information.
Okay, Mr. Fry, how do you wish to proceed today?
Your Honor, so in district court, we did place a plea agreement on the record in this case, where my client would plead to count 3, weapons felony firearm, no supplements. Counts 1 and counts 2 would be dismissed. You understand that that is a mandatory 2 years of incarceration. And he wishes to enter that today.
Okay, Mr. Stinson, want to raise your right hand for me?
Yes, ma'am.
Thank you. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, Mr. Stinson, you've heard the statement of your attorney. Is it your intention to plead guilty to count 3, weapons felony firearm, which carries a mandatory 24 months with the Michigan Department of Corrections, which would be served consecutive to the sentence you're currently serving? Do you understand that?
Yes, ma'am.
All right. And is it your intention to plead guilty to that count?
Yes, ma'am.
All right. Are you satisfied with Mr. Fry as your attorney and the advice that he has given you?
Yes, ma'am.
Neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Sneed?
Yes, Your Honor.
And Mr. Fry?
Yes, Your Honor.
And Mr. Stinson, is that correct as far as you're aware?
Yes, ma'am.
Right. So, Mr. Stinson, if a guilty plea is accepted, there will be no trial. This means that you'll be giving up rights you would have had at a trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and the court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. Hold on 1 second. I don't appear to have Miss Adams, and I don't know why. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Sir, do you understand if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you, sir?
No, ma'am.
All right, so Mr. Stinson, how do you wish to plead to the charge that on or about December 18 of 2024 in the city of Adrian in the county of Lenawee that you did commit the offense of weapons, felony, firearm, guilty or not guilty?
Guilty.
Okay. So Mr. Fry and Mr. Sneed, just for my own information, he's currently an MDOC inmate, but he wasn't at the time the offense occurred. Is he incarcerated on an offense he was on parole for?
Yes.
It's a parole
Okay,
violation
so-
he's done there for.
Okay, so this would be consecutive. Okay, I just wanted to make sure that, okay. And you said you were gonna plead guilty, Mr. Stinson?
Yes, ma'am.
Okay, has anybody made any threats or promises to you to induce you to plead guilty to this charge?
No, ma'am.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Sneed?
No, Your Honor.
Mr.
No,
Fry?
Your Honor. No, Your Honor.
All right, so Mr. Stinson, obviously it's a flat 2 years, so there's not been any agreement, but has your attorney promised you anything else in regards to sentence?
No, ma'am.
Right, and it's your own choice to plead guilty?
Yes, ma'am.
All right, so Mr. Stinson, on December 18th of 2024, were you in the city of Adrian in the county of Lenawee?
Yes, ma'am.
All right, and at that time, did you have in your possession a handgun?
Yes, ma'am.
All right, and when you had this handgun with you, were you involved in some kind of altercation or felonious assault?
Yes, ma'am.
Okay, and you have a prior record and felony convictions, so you aren't legally allowed to possess a handgun, is that correct?
Yes, ma'am.
Mr. Sneed, is there anything else I need to ask on that one?
No, I'm satisfied, Your Honor. Thank you.
Has the court complied with MCR 6.302 B, C, and D? Mr. Sneed?
Yes, it has. I just wanted to add there was an additional term of no contact with certain individuals that was on the written plea form, and I can add those onto the record now if the court doesn't have the written plea form.
Okay, was it, oh, okay, I don't, but go ahead.
It is Rihanna Walters, Monica Tincher, and Dale Meeks.
All right, so Mr. Stinson, you understand there's gonna be a no contact with those individuals?
Yes, ma'am.
Okay, I accept the plea. It has been given understandably and I'm sorry, Mr. Fry, has the court complied with MCR 6.302 B, C, and D?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Fry, are you available May 29 at 8:15 in the morning?
Yes, Your Honor.
All right. Now, Mr. Stinson, you do have the right to be present in person for sentencing, or you can appear via Zoom. I leave it up to you. What would you like to do?
Just a Zoom.
Zoom, okay. Where are you currently located?
St. Louis.
St. Louis, okay. All right, so someone from the Michigan Department of Corrections will reach out to you and they're gonna do a pre-sentence report. When they talk to you, be truthful with them about your background, the events that occurred, make any corrections if they have anything wrong in your old reports. And then you will get a copy of that pre-sentence report. Mr. Fry is really good about trying to reach out to people in advance, but sometimes we do struggle to meet with people from MDOC. So if he is not able to meet with you in advance, I will give him an opportunity on that morning. So I will see you back on May 29th at 8:15. And Ms. Walsh, you don't need to talk to him today, right? All right. Thank you, Mr. Stinson.
Yes, ma'am.
All right. You have a good day.
You too.
All right. Yeah, see you soon. All right. In the matter of the people of the state of Michigan versus Britney Rener Foor, Foor, file number 24-21993FH. I have Isaac Sneed appearing on behalf of the people. I have Brian Fry appearing on behalf of Ms. Foor. This is the date and time set for a pretrial. I still do not have fingerprints on Ms. Foor. And
I
so
went and
Ms.
got them
Foor,
done.
you did?
Yes, I have the number, the confirmation number also.
No, perfect. When did you get them done?
Like a couple months ago after you warned me the last time.
Okay. All right. Okay, if you can get that confirmation to Mr. Fry or something, that would be great. Thank you so much. All right, so
I have it right
Mr.
now.
Okay, but you're not here, so just get it to
Okay.
Mr. Fry. So, Mr. Fry, how would you like to proceed on behalf of Ms. Foor today?
Your Honor, obviously I was here on the other one, but this got moved to next week. This pretrial is scheduled for the 23rd.
All right, so we will move this for sure to April 23rd at 8:30 in the morning. And did you do a stipend order on that, Mr. Fry?
Yeah, that should be in the file. That was done a couple weeks ago, I think.
Yeah, it is. So thank you, but we still had
Okay.
it on for today. All right, Ms. Foor, I'll see you next Wednesday at 8:30, okay?
Okay, thank you.
Thank you.
Thank you.
Thank you. All right, so we'll get rid of MDOC. Mr. Smith, your client's here, right?
Yes.
All right, you can bring him up to the podium. Let me see here. Who do I got? Dave McCready, Darren Coast, Michael Dagger, Margosian. Hey, this is Judge Anselone. So one of them on your jail list for Ricardo Garcia, he was actually an Old Saver file, not mine.
Okay.
But I am ready for David Walker, James Rener, Elvin Graves, and Jalen Tatum.
Okay, we'll get those going.
Awesome, thank you so much. Mr. Smith, you want to come up to the podium with your client? All right, Mr. Wolfheis. Mr. Wolfheis. All right, so this is in the matter of the people of the state of Michigan versus Stephen Richard Wolfheis, file number 24-21939FH. I have Russell Smith appearing on behalf of Mr. Wolfheis, and I have Isaac Sneed appearing on behalf of the people. So I'm going to hand this down to you. It looks like they didn't do fingerprints on this file, so this is a Tecumseh Police Department case. So there's one we still need fingerprints on. So if you can just reach out to the Tecumseh Police Department and get those taken care of on that file, that would be great.
Okay.
Does my client just need to call them and
Yeah,
make
yeah.
arrangements?
Just give that to him and
Sure.
he can just call them.
Yes, there was some confusion on that, Judge.
So sometimes when you have 3 or 4 files, they get prints, but not on all of them.
They've done it, but you need to do it on each file. So this hasn't been done. Yeah, it's not a problem.
It's not an issue.
Number of charges that you faced and you did
Yep.
all but this one. So you need to contact the Townsend Police Department, take that form to them and get your fingerprints done. Okay?
Yep.
I
They'll
think
do
you have
it
to
either
at
at the Tecumseh Police Department, I think.
You have to do it there.
Okay,
All right, it's just a ministerial thing. It shouldn't-
not a big deal. All right, so Mr. Smith, how would you like to proceed today on behalf of Mr. Walters?
Judge, we did receive a plea agreement from Mr. Sneed in this matter. It did indicate that my client was going to plead guilty. I'm asking Mr. Sneed if he has any objection to a no contest plea in this matter.
I have no objection.
Mr. Sneed, did you send to us a copy of the plea agreement? Or is that what you got in front of you?
I have it, Judge.
Do you and your client sign it?
We did. May I approach?
Well, actually, my bail will come get it and let me get a copy of it. And that way it'll help me to take the plea.
That'll be terrific, Judge.
All right.
It's one of the
Miss-
reasons I wanted to
Yeah.
appear in person.
Miss Adams, thank you. Can I just get a copy of that? Thank you. All right, give us just a minute to get a copy of that.
His fingerprints, it's not included. Yeah, so-
What's the original?
I'll give you a copy and I'll keep the original, all right? It's got the signatures on it. All right, and so it's marked no contest now.
Yes.
So, looks like the plea agreement is that on, is it, all right, on file number 24-217-34FH, he's going to plead no contest to an added count 2 of aggravated assault, which is a 1-year misdemeanor with a killebrew agreement that there will be no upfront jail. File number 24-21938FH, 24-21939FH, and 25-22158FH will be dismissed at the time of sentencing. So, let's see here. All right, and it is signed by Mr. Sneed, Mr. Smith, and Mr. Wolfheis. So, Mr. Wolfheis, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, can you move that microphone a little bit? And then Mr. Wolfheis, can you repeat that a little bit louder?
Yes, I do.
All right, excellent. So Mr. Wolfheis, you have heard the statement of your attorney, the prosecuting attorney, and myself reading off the plea agreement. Is it your intention to plead no contest on file number 24-21934FH to an added count of aggravated assault? Say it loud.
Yes.
All right, are you satisfied with your attorney and the advice that he has given you?
Yes.
And neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court other than no upfront jail. Is that correct, Mr. Smith?
It is.
Mr. Sneed?
Yes, Your Honor.
All right. Is that correct as far as you're aware, Mr. Wolfheis?
Yes.
All right. If a guilty plea is accepted, there will be no trial. This means that you'll be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be present or presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Wolfeis?
Yes.
All right. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No.
How do you wish to plead to the charge that on or about October 3rd of 2023 in the city of Tecumseh in the county of Lenawee, that you did commit the offense on the amended information count 2 aggravated assault? You can say not guilty or no contest.
No contest.
Okay. Has anyone made any threats or promises to you to induce you to plead no contest to this charge?
No.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand if I accept this plea, you're going to give up any and all claims that your plea is given as a result of promises or threats that were not disclosed on the record during the hearing, or that it was not your own choice to enter the plea? So I've gone through your rights. So it's just saying basically you can't come back later and say we promised you or threatened you something.
Yes, I understand.
Okay, all right. Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead no contest? Mr. Smith
No, Judge.
and Mr. Sneed?
No, Your Honor.
All right, in terms of fines, costs, length of probation, has your attorney promised you any particular sentence or estimated what your sentence will be?
No.
Okay. Is it your own choice to plead guilty?
Yes.
Okay, or no contest, I mean.
Say yes.
Yes.
Okay, so are you going to place factual basis on the record?
I will, Judge. Just for the record, the reason for the no contest plea is possible civil liability.
Hold on.
So we have that.
It's okay, it's okay.
The other thing that I think is abundantly clear but wasn't placed on the record is that the top count in this case is going to be dismissed as part of the plea agreement.
Yes.
Everybody understands that. It's for the purposes of my client.
Okay.
Judge, I'm referring to a Tecumseh City Police Department report regarding an incident that occurred on October 3rd, 2024. City of Tecumseh, County of Lenawee, State of Michigan, indicates that on that date that my client and the victim, Ken Teagarden, got into a verbal exchange, something to do with scrap metal. It turned into a dialogue. Later on, it was indicated that by Mr. Teagarden that he was in the middle of the road when Stephen backed into his driveway, then drove directly at him. That would be the substance of the charge, Your Honor.
So he was in a vehicle, backed up in a threatening manner?
He backed up into his driveway and then drove toward directly at the victim.
Okay. Mr. Sneed, anything to add to that?
That's accurate. I just want to clarify the date was October 23rd of 2023 rather than 2024.
So I have October 3rd of 23 in my felony information. So when you amend the information,
I would stipulate to the October 3rd, 2023, Your Honor.
so is it October 3rd or 20? Oh, I thought you said 23rd. I'm sorry. All right. So
Actually did, Your Honor, just to
okay.
make you know that you're sharp this morning.
I'm on a roll this morning. All right. So based on the facts placed on the record and from the information contained in the police report as stated by Mr. Smith, the court finds beyond a reasonable doubt that on October 3rd of 2023 in the city of Tecumseh in the county of Lenawee, the defendant did commit the offense of aggravated assault by driving towards the victim in this matter in a way that would be deemed assaultive or put the victim in fear of an assault, and therefore the court accepts the no contest plea. So Mr. Sneed, has the court complied with the MCR 6.302 B, C, and D?
Yes, thank you, Your Honor.
All right, and Mr. Smith, has the court complied?
Absolutely, Judge.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them other than the Killebrew agreement that was placed on the record. I'm going to refer this matter, so Mr. Wolfheis, this is a misdemeanor, so it's going to be referred down to the district court probation department, okay?
Okay,
So not tomorrow, but a week from tomorrow, so it would be Thursday, April 24. I need you to report to district court probation between 8 and 10 and ask to see Mike McCarron.
What was that name, Judge?
Mike McCarron.
is there any way I can report today? I don't drive.
So,
I'm battling epilepsy. I can't get my license for a couple more months.
all right,
so
Miss Adams.
Otherwise, I'm riding a bike everywhere.
Okay, hold on. So we usually need to get the file or the plea agreement form. Miss Adams, do you think we could take this file down to Mr. McCarron today? And maybe if he's here, you could see Mr. Woldice?
I'll check.
Okay. I don't know if, you know, what his schedule is other than that, but we'll try, okay? Mr. Smith, I have May 29th available for sentencing at 8:15 because your client's not facing jail. You can do that via Zoom. That might help Mr. Wolfheis if he's not able to get here. Mr. Wolfheis, do you want to appear in person or via Zoom?
Zoom would be much easier, please.
All right. Is that all right with you, Mr. Smith?
Absolutely, Judge.
All right. So we'll set this for May 29 at 8:15 in the morning for sentencing via Zoom. And all right. And Mr. Wolfheis, when you meet with Mr. McCarron, be truthful with them about your background, the events that, or no, you don't have to be truthful about the events that occurred because you pled no contest. But just be truthful with them about your background. You don't have to make a statement about the events that occurred. Do you understand that?
Yes.
Because you pled no contest. And then we will send a copy of this to Mr. Smith, get a hold of Mr. Smith about a week before sentencing and he'll review it with you. And then you guys can Zoom in on May 29 at 8:15 in the morning. So if you want to have a seat for just a minute, we'll find out if Mr. McCarron. Yeah.
Mr. McCarron's down there. He's aware. I'm sending it to him right now.
Okay. Do you want me to send the file down or what do I need? Anything
No,
from the file?
I just email him the paperwork. We're all set.
Okay. So go down to district court probation and ask for Mike McCarron.
Thank you very much
All right.
for the accommodation.
Thank you, Mr. Smith.
Yes,
Good to
have a
see you in
wonderful
person.
day. Yes, good to be here.
All right. Let's see. Mr. McManus? Is it Andrew Wright? Oh, stand there right with you. All right. So I have, Mr. Rener and I have, let me see, Mr. Walker. Mr. Dagamar-Gozzi, do you need a breakout room with Mr. Walker?
If I could, Your Honor, please.
Yep, hold on a second. Give me 1 second. And then, let's see, so Mr. Walker, you are in jail resume 3. And Mr. Dagamar-Gozzi. All right, and Mr. Renner, your attorney is Sam Malaro. Mr. Malaro, do you need a breakout room with Mr. Renner?
Judge, I need a breakout room with Mrs. Walsh, real brief about his probation cases.
Okay, but can you call her? Are you at home or at the office, Miss Walsh? Oh, all right, I'll put you in a breakout room.
Won't
with
take long,
Mr.
Judge.
All right, because I think she's watching my docket, that's why.
Yeah, I am.
All
I need to
right,
be able to
I'll give,
take it, please.
yep, so let me find Mr. Malaro in my Zoom. There he is. All right, go ahead. Okay. All right, so this is in the matter of people of the state of Michigan versus Andrew Gordon Wright, file number 25-22169FH. Counsel, can you state your name and P number on the record, please?
Yes, Your Honor. Attorney Martin McManus, P 41543, attorney for Andrew Wright.
Excellent, thank you. And I have Dave McCready appearing on behalf of the people. This is the date and time set for a pretrial, or no, yep, pretrial conference in this matter. Mr. McManus, how would you like to proceed today?
Your Honor, this time I'm requesting for another pretrial. I did receive the majority of the discovery. I'm just waiting on some video, and then we can have some meaningful discussion and try to resolve it.
All right, and how far out are you looking?
Mid-May.
Mid-May, okay. No objection to that, Mr. McCready?
No objection.
All right, so, mid-May.
We're doing Wednesdays.
Always Wednesday.
Always Wednesdays.
Always Wednesday. So I have May 14 or May 21. You can do this via Zoom.
Okay.
As you can tell, most people do now. So you are able to do it via Zoom, but May 21 or May 14? Which one?
May 21, Your Honor.
All right, so we'll do May 21. Let me find you here. 5/21 at 8:30 in the morning. Do you have our Zoom instructions?
I do not, but I can.
Oh, Miss Adams, could I get 2 copies of our Zoom instructions, please? Oh, never mind, my bailiff has this. So he's gonna give you each copy of that. And so Mr. McManus, I'll need you to do a stipulation in order to adjourn from today to May 21. And Mr. McCready, can you sign your name with permission?
That's fine.
All right. All right, so Ms. Wright, your bond's continued, and we will see you back either in person or Zoom on May 21 at 8:30 in the morning. Thank you.
Thank you, Your Honor.
Thank you. Thank you, Mr. McManus. I don't think I've seen you in person in forever.
I know it.
I know. Have a good day.
Thank you.
All right, so I got Mr. Malaro back, Ms. Walsh, that was May 21. I believe we said at 8:30 in the morning for Wright. Okay. So, Mr. Malaro, are you ready on Mr. Rener? You need to talk to Mr. Rener.
Yeah, if I could just real quick, Judge, explain to them what we're gonna do.
Okay. All right, Mr. Rener, I am going to put you in a breakout room. Jail Zoom 4. Uh-oh. Hold on, I'm gonna close all these rooms. I could have screwed this up. Give me a minute. Mr. Dagger kind of popped out and foiled my plans of closing and moving rooms around. So hold on a minute.
I did that on purpose, Judge.
I know you did. You always do.
Yep.
All right. So I'm sorry I screwed up the rooms, so I'm gonna do it again. So I'm gonna assign Mr. Malaro, and where did you go, Mr. Rener? And Mr. Rener to a breakout room. Sorry about that. Okay. Oh, wait. Is that the right one? Yeah. Okay. So Mr. Daggermark goes in, we get Mr. Walker's file. All right, this is in the matter of the people of the state of Michigan versus David Walker, file number 25-22215FH, 25-22165FH, and Michael Daggermark goes in appearing on behalf of Mr. Walker, and I have Isaac Sneed appearing on behalf of the people. I have 2 files, as I said, on 25-22215FH, we're set for arraignment. Mr. Daggermark goes in to waive the reading of the following information.
Yes, Your Honor.
Do you acknowledge receipt of the prosecutor's request for discovery and witness list?
I do.
And Mr. Walker has a pretrial on the other file. So how do you wish to proceed today, Mr. Daggermark goes in?
Well, Your Honor, there's actually a 3rd file, but it's not up for today. It's up for a circuit court arraignment next week. And so my request and idea would be to adjourn the 2 cases set for today onto next week's docket, so we can get all 3 all on the same page, if that's works for it as well.
Yep. So I will set these over to April 23rd. No, April 23rd at 8:30 in the morning. And for pretrial, can you do the step in order to adjourn Mr. Dagger Margosian on the pretrial?
I can do that.
And then we'll do the notice of hearing on the arraignment, all right?
Thank you, Your Honor.
So Mr. Walker, we'll see you back next week on all your files, okay?
Thank you, Your Honor.
Thank you. Okay, so we're back with Mr. Rener and Mr. Malaro, how would you like to proceed with Mr. Rener?
Your Honor, at this time, we would acknowledge receipt of the information, waive its reading in open court, waive any defects as the time and place of service. Mr. Rener will stand mute as to count one, and the habitual offender fourth notice. Ask the court to enter a plea of not guilty and set the matter for pretrial. We would further acknowledge the witness list. We'd also ask that the probation violation matters be set out as well.
How far out do you want these set?
Well, I don't think we need to go very far, Judge. I'm probably going to ask to have a bench conference to iron out some details, and then I think we'll be ready to resolve the matter.
All right, my next available is May 14 at 8:30 in the morning. Now, Mr. Rener, that's not right away, but Mr. Malaro will get in fairly quickly with me. And then if there's a resolution, we'll bring in right away. Are you not here May 14, Mr. Malaro?
Checking, Judge. It says I'm here, so I can do it.
Okay, so we'll set these all over to May 14, and Mr. Malaro, you can reach out to Miss Adams to get a bench conference, all right?
Thank you, Judge.
All right, we'll see you back on that date, but we'll probably see you sooner, Mr. Renner. Thank you.
Thank you.
That one done, and now I have a ton of people in my waiting room, so let's go to Aaron Lambus. Hold on. All right, Matt Murphy, Sam Malaro, hold on. Chad Stewart, Mr. Malaro, I have Chad Stewart.
Okay.
All right, Mr. Stewart, if you could go ahead and unmute your device and start your audio, please. All right, there he is. All right, this, Mr. Stewart, go ahead and unmute your device. Mr. Stewart is going to work on Mr. Malaro. I have Mr. Graves. So while Mr. Stewart's trying to unmute his device, let's move on to Mr. Graves. So in the matter of the people of the state of Michigan versus Elvin D. Graves, file number 23-21428FH. This is the date and time set for a violation. This is a violation of probation. And Mr. Malaro, you're on this one?
I am, Judge, but I have it down as a pretrial.
Probation violation pretrial, I think. Do you have him on another file?
Well, he has numerous files.
Oh, you know what? I'm sorry. It looks like, let me see here. Pretrial contempt arraignment, failed to appear for a pretrial. You're right. I just had it written down wrong. So it is he failed to appear for pretrial on August 7th, so it's contempt of court. I saw the public defender thing, so I thought it was a bot. So it is a pretrial on the underlying felony. So, Mr. Malaro, how would you like to proceed with Mr. Graves?
Judge, I spoke to Mr. Graves yesterday, but what we talked about there was a little confusion. If I could have a brief breakout, I think we could get this maybe across the finish line.
So I'm going to open up a breakout room. We'll join it. All right, Mr. Stewart, you have to unmute your device. Down on the screen on the left, there should be like a red microphone with a line through it. And you just touch that and it should unmute you.
Which clients here?
Aaron Lambus. Matt, I'm bringing Aaron Lambus in. Mr. Murphy.
Yeah, no, we could proceed on the record with him.
Excellent. So, change that screen name. This file. This is in the matter of the people of the state of Michigan versus Aaron Wayne Lambus. Mr. Lambus, could you unmute your device and start your video? Mr. Stewart, why don't you try calling back in? Disconnect and call back in and it might fix it, all right? All right. So I have Isaac Sneed appearing on behalf of the people. I have Matthew Murphy appearing on behalf of Mr. Lambus, and Mr. Lambus is appearing via Zoom. This is the date and time set for a pretrial conference. Mr. Malaro, how would you like to proceed on behalf of Mr. Lambus?
Your Honor, in regards to Mr. Lambus, the offer from the people right now is for him to plead to count 1, resisting obstructing an officer, a 2-year felony. Domestic violence, first offense, I believe that's count 7. And then count 9, which is a misdemeanor assault of a medical professional. It'd be a no contest to those. At this point, I was asking for us to set another pretrial on this matter. And then I was going to ask if I could just talk to Mr. Lambus in a breakout after this, just to discuss it with him if the court could allow me to.
So Mr. Coast did provide a letter dated April 14th regarding Mr. Lambus. He said that he is currently at Dawn Farms. He entered there on March 15. It's a 32-day program. So, Mr. Lambus, are you still in that program or have you transitioned to transitional housing?
I'm in the process of transitional housing right now.
Awesome. Good job. All right. So, yeah. So, Mr. Murphy, I will give you a breakout room with him, and I will set another pretrial for May 14 at 8:30 in the morning. Mr. Lambus, I will tell you that completing the program and staying in transitional housing and doing well goes a long way. All right.
Your Honor, I'm sorry. There was one other thing I wanted to bring up. I wasn't sure if Mr. Lambus, if he still has a scram unit on that he's ordered to have on or not. If that was the case, I was asking for that to be removed because of his position. I thought maybe it was left on, even though he was being going into treatment.
No,
we got it all taken care of.
All right, thank you. I apologize for that.
All right, I can't hear everybody at once. Darren, what were you going to say?
Yeah, I was just going to mention that we did take that off, and that was a condition as long as he entered into inpatient, which he did. So we took that off. So, but
Thank you.
Aaron actually voluntarily put himself in a Dawn Farm, so it wasn't court ordered.
All right, so Mr. Lambus, good job, and we will see you back on May 14 at 8:30 in the morning. All right.
Okay.
All right, and I'm going to give you a breakout room in a minute with Mr. Murphy, but first I'm going to make Mr. Murphy take care of Harley Olmstead.
Okay.
So just hang tight. All right.
Okay.
All right, Harley Olmstead, could you please start your audio and your video for me, please?
Yes, ma'am.
Oh, there we are. And grab your file somewhere. is in the matter of the people of the state of Michigan versus Harley Olmstead, file number 25-22171FH. I am Matthew Murphy appearing on behalf of Mr. Olmstead. Isaac Sneed appearing on behalf of the people. This is date time set for pretrial conference. Mr. Murphy, how do you wish to proceed?
Your Honor, I was going to ask if we could set another pretrial for May 14th as well as with Mr. Olmstead. I was just wanting to see how he does in his program. He's doing well right now. I just want to give him some more time, and then we address the offer from the people at that point.
Okay, so Mr. Olmstead, I'm going to set this over to May 14 at 8:30 in the morning for a pretrial, and we will see you back on that day. Mr. Murphy, you can do the step in order to adjourn. Mr. Sneed, can you sign your name with permission?
Yes, thanks.
All right, you're all set, Mr. Olmstead. Your bond conditions are continued. Thank you.
Thank you, ma'am. You have a good day.
Thank you, Mr. Olmstead. I'll talk to you soon,
too.
okay?
All right.
All right, and Mr. Murphy, I think that's all I had with you, so I'm going to put you in a breakout room with Mr. Lambus at this time.
Okay, thank you.
All right, there we go. Go join that breakout room. Chad Stewart, I'm gonna bring him back in. I got Mr. Graves. Okay. All right, Mr. Malaro, how did you wish to proceed with Mr. Graves? I got nothing. And my laptop in my office does the exact same thing, and it really makes me mad. So go ahead, Mr. Malaro.
Can you hear me okay now, Judge?
I can. I feel like it's like the mic has to catch up to you, you know?
I think it's IT. They just like screwing with me.
They did say that, but
Yeah, I know. I knew it. Judge, Mr. Graves has been kind of absent without leave for a little while. I'd like to adjourn this out and set up a bench conference, see if we can't get this resolved.
how about, let me see. So I filled out I can do May 14, and then you can set a bench conference. Mr. Graves, obviously that's a month away, but once I have the bench conference, if there's a resolution, Mr. Millar will bring you back in right away, all right?
Okay.
All right, so I will set a pretrial for May 14 at 8:30 in the morning. And Mr. Graves, we'll see you back on that day. And Mr. Sneed, can you sign your name with permission?
Yes.
Yes.
Okay, excellent. Takes care of Graves. All right, you're all set, Mr. Graves. Thank you.
Thank you.
Thank you.
Can you tell them I'm ready for Mr. Tatum?
Yeah.
Awesome, thank you. All right, Mr. Stewart, we're gonna try this again. I know, I'm sorry. All right. Well, you wave at me if you can hear me, Mr. Stewart. Okay, perfect. All right, so this is in the matter of the people of the state of Michigan versus Chad Stewart. We have two files, 25-22167FH and 25-22168FH. I have Salvatore Milaro appearing on behalf of Mr. Stewart and Isaac Sneed appearing on behalf of the people. I do have a letter from Darren Coast, our pretrial services coordinator. He said, although Mr. Stewart had tested positive 4 times in March, he's been doing really well. His last 7 drug screens have been completely negative. He would like to adjourn the contempt out for at least a month to continue to monitor his progress. You know, Mr. Stewart does have a lot of tools in his toolbox for sobriety, and hopefully he's putting those into good use. So I'm pleased to hear that. So Mr. Milaro, how would you like to move forward on Mr. Stewart? Can't hear you. Sorry.
How about now?
I can hear you now.
So, Judge, I would also like to adjourn the pretrial out to monitor things and then see if we can't reach a resolution at the new date. I think this might be the first time up.
All right, so I will set this out to May 14 at 8:30 in the morning on both files. And Mr. Milaro, you can do the step in order to adjourn. Mr. Sneed, can you sign your name with permission?
Yes, Your Honor.
All right, so Mr. Stewart, we'll see you back on that day. I'm proud of you. You have a period of sobriety going on right now. I know how hard that is, so I wish you the best of luck, and we'll see you back on that day, all right? Thank you.
Thank you, Judge.
Thank you, Judge.
Thank you. All right, let's see. I got Trevor Austin. We're waiting on Jalen Tatum. Trevor Austin is Rhonda. Adam 9 is Rhonda. I have Eric, no, she waived arraignment. So let's see what I got. I'm just waiting on. Eric Nolan got picked up yesterday, so he's probably still looking, right? 2, 3, 4, 6.
No, he's in 7 block.
Yes?
Yes.
And so Tatum, let's see, Nolan. All right. You know, I went to Meijer yesterday and they were sold out of Easter bunnies, chocolate Easter bunnies. Really? Luckily, Aldi had them, but usually I buy Mary Easter bunny and. Oh my gosh. I mean, I have 30 of them in my side yard, but. Well, I got nobody, so I'm gonna take these files to Becky real quick and take a break. So Miss Spade. Okay, thank you, Judge.
Gotcha.
We'll be with you in just a second, Mr. Tatum.
Okay.
Sorry. All right, so Mr. Malaro, I have Mr. Tatum. All right, this is in the matter of people of the state of Michigan versus Jalen Jamal Tatum. File number 25-22186FH. I have Salvatore Malaro appearing on behalf of Mr. Tatum. I have Isaac Sneed appearing on behalf of the people. This is date and time set for a pretrial. I do have a plea agreement form that has been signed by Mr. Tatum, Mr. Malaro, and Mr. Bandetto. The plea offer is that Mr. Tatum would plead guilty to count 1 and count 2. Count 1 being aggravated indecent exposure, which is a high court misdemeanor carrying a maximum penalty of up to 2 years in prison and $2,000 or $2,000 fine. And then he would plead guilty to count 2, which is another count of aggravated indecent exposure, which also carries a maximum penalty of up to 2 years in prison and or a $2,000 fine. They will dismiss the sexually delinquent person indecent exposure notice. But those 2 offenses are tier 2 offenses. Is that correct, Mr. Malaro?
I believe so, Judge.
All right, and then that will require, is tier 2 mandatory 25-year sex offender registration, or?
Judge, he's already required to register, so I think he's got to register for that time period anyways.
Sure he does. Okay. All right, Mr. Let's see. And then I don't see that there's any other agreement regarding sentencing. Is that correct, Mr. Sneed?
Yes, it is.
Is that correct, Mr. Malaro?
Yes, Judge, that's correct.
All right, so. All right, Mr. Tatum, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Can you state your full name for the record?
Jalen Jamal Tatum.
All right, you can put your hand down. So, Mr. Tatum, you've heard the statement of myself, your attorney, the prosecuting attorney. Is it your intention to plead guilty to count 1 and count 2, both of which are aggravated indecent exposure, which carry a maximum penalty of up to 2 years in prison and or a $2,000 fine, along with sex offender registration? I think it's for 25 years.
Yes, Your Honor.
All right. So, Mr. Tatum, are you satisfied with your attorney and the advice that he's given you?
Yes, Your Honor.
And neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Sneed?
Yes, Your Honor.
Is that correct, Mr. Malaro?
Yes, Judge.
Is that correct as far as you're aware, Mr. Tatum?
Yes, Your Honor.
If a guilty, you got to speak up for me, Mr. Tatum. Can you repeat your answer?
Yes, Your Honor.
Okay, thank you. So let's see, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses you have to appear for your defense at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
You are not a citizen of the United States of America. A conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, Your Honor.
All right, so Mr. Tatum, how do you plead to the charge that on or about January 5 of 2025 in the city of Adrian in the county of Lenawee, that you did commit the offense listed under count 1, aggravated indecent exposure, guilty or not guilty?
Guilty.
All right, and how do you plead to the charge that on January 5 of 25 in the city of Adrian in the county of Lenawee that you did commit the offense listed under count 2, aggravated indecent exposure, guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to these charges?
No, Your Honor.
You understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes, Your Honor.
Is prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Malaro?
None, Judge.
Mr. Sneed?
No, Your Honor.
Has your attorney, Mr. Tatum, promised you any particular sentence or estimate what your sentence will be?
No, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
All right, so Mr. Tatum, on January 5 of 2025, were you in the city of Adrian in the county of Lenawee?
Yes, Your Honor.
So at some point, you were somewhere that was open to the public when you exposed your genitalia. Where were you at?
I was in my cell in my cell in 887 block. I was basically.
Were you at, wait, hold on, you were at the jail?
Yes, Your Honor.
Okay, so on January 5, you were an inmate at the Lenawee County Jail, and then, okay, so at some point you exposed your genitals in public to whoever could have walked by, is that correct?
Yes, Your Honor.
Okay, and, all right, were you fondling yourself?
I wasn't masturbating. I wasn't like stroking my genitalia. I had it out and I was moving it back and forth. I was definitely doing that. I wasn't on my medication at the time.
Okay, so you did that, but you did it twice, right?
Yeah.
All right, are you satisfied, Mr. Steen?
Yes, thank you.
All right, has the court complied with MCR 6.302 B, C, and D? Mr. Malaro?
It has.
Mr. Steen?
Yes, thank you.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. So Mr. Tatum, someone from the Department of Corrections is going to meet with you to do a pre-sentence report. When you meet with them, be truthful with them about your background, the events that occurred. They will prepare a pre-sentence report. We will provide a copy to Mr. Malaro. He will review that with you in advance of sentencing. And do you want to appear in person or via Zoom, Mr. Tatum?
In person.
All right, so we will put in person and all right, we'll see you back on that day. Thank you, Mr. Tatum. You're all set.
All right, thank you.
What was the date, Judge?
May 29th at 8:15.
Thank you, Judge.
All right. Thank you. And I think you're all set, Mr. Malaro.
All right, thank you.
Thank you.
Always a pleasure.
Happy Wednesday. All right, so I got Adam 9, I got Trevor Austin. I can't get the June. Mr. Nine, can you hear me?
Yes.
All right, trying to call the jail, Rhonda. So this is in the matter of the people of the state of Michigan versus Adam Matthew 9, file number 24-22018FH. I have Rhonda Underwood appearing on behalf of Mr. 9, and I have Isaac Sneed appearing on behalf of.
Hello.
Hey, this is Judge Anzalone. I am ready for Eric Nolan first, and then I'm ready for, let me find my jail list. I am ready then for, oh, well, that's it, Eric Nolan.
Just Nolan?
Yeah, just Nolan. Thank you.
Okay.
Bye. This is date time set for pre-trial. So Miss Underwood, how would you like to proceed with Mr. 9?
Your Honor, we would ask for another pretrial in this matter. Your Honor, as the court is aware from the bench conference we had, we're trying to work out a diversion in this matter. And I've explained the situation to Mr. 9, but I just think it's a matter of resolving what the amount is going to be with Ms. McClure, because I want an absolute clear understanding between all the parties what that is going to look like.
Okay, so I'm going to set this over for pre-trial on May 14 at 8:30 in the morning. And Miss Underwood, if you can prepare the stipend order, Mr. Sneed. Yep, Mr. Sneed, can she sign your name with permission?
Yes, thank you.
All right, you're all set, Mr. 9. We'll see you back on May 14. Thank you.
Thank you, Mr. 9, thank you for your patience.
Oh, no problem. Thank you.
Thank you.
Have a good day.
You too. What's that? All right, so Gonzalez Rodriguez, is he here from MDOC?
No, that's not.
I don't think he,
I know.
No, he's not here yet.
I don't think
Okay,
that's
sometimes
till
they get-
11.
I know, but sometimes they get here early. All right, Mr. Austin, can you hear me?
Yeah, I can hear you.
Awesome. This is in the matter of the people of the state of Michigan versus Gonzalez Rodriguez, Bonica, Nolan. All right, so I don't have Trevor Austin, but in the matter of people of the state of Michigan versus Trevor Austin, file number 22-20788FH. I have Brenda Underwood appearing on this probation violation pretrial. And Ms. Adams, I don't know why, I just don't have the file. Might have brought it back to you at 9.
I don't think I was appointed on this quite. Yeah.
I don't know. I mean, hold on, Mr. Austin. I need to get a file. So
okay.
Hold on. I have you appointed, but that doesn't mean anything. All right, Mr. Nolan, good morning.
Yes, ma'am. Good morning.
All right, let me grab your paperwork. Gonzalez Rodriguez, Bonica, Nolan. All right. So in the matter of the people of the state of Michigan versus Eric Joseph Nolan, I have two files, 24-21927FH, 24-21928FH. Both of these files are set for arraignment today on a request and warrant for probation violation. Both of them allege that on November 8th of 2024, Mr. Nolan was placed on probation and ordered not to use any controlled substances. On April 7 of 2025, it shows he tested positive for marijuana and cocaine, admitting to using the same. So Mr. Nolan, do you understand those are the allegations against you?
Yes, ma'am, I do.
All right, on file number 24-21928FH, you were convicted of an attempted R&O, which carries a maximum penalty of up to 1 year in jail. And on, well, hold on a second. Let me see here. Probation. And then that's attempted RNO. Okay. Well, I don't know, the felony information says something about a controlled substance, possession of analog, but I don't have that on this file, so I don't know what that's about. Thank you. And so the maximum penalty on that file could be up to 1 year in jail if you plead guilty or are found guilty. Let me see. So that's 2-7. And then on 24-21928, that's the one with the, all right, on that file, you pled guilty to a controlled substance, possession of analogs, which carries a maximum penalty of up to 2. I see what I did. So on file number 24-21928FH, if you plead guilty or found guilty, you could be facing up to 2 years in prison. And on file number 24-21927FH, if you plead guilty or found guilty of this violation of probation, you could be facing up to 1 year in jail. So, Mr. Nolan, you do have a right to have an attorney represent you at this and all subsequent hearings. If you can't afford to hire one, we can appoint you one at public expense. Would you like an attorney appointed to represent you?
Yes, ma'am.
Okay, and Miss Adams, do I, okay, she printed off this. Hold on 1 second. That's 23. All right, so Miss Underwood, Mr. Austin did request court-appointed counsel on February 18th of 25. Miss Adams may have just sent you the paperwork on Mr. Austin.
I have the information, Your Honor, I think.
All right, so would you like to speak with Mr. Austin in a breakout room?
Yes, that would be fine, Your Honor.
All right, so Mr. Nolan, give us a moment. I'm gonna put Mr. Nolan, you in the breakout or in a waiting room. And then Mr. Austin and Miss Underwood, go ahead and join the breakout room I've just invited you to.
Okay, thank you, ma'am.
You're welcome. I don't know what happened.
Rates is just from these, I guess they are yours.
I have never met that guy in my life. I don't think he's ever showed up for recovery court. Okay. Miss Spade, Ricardo Anthony Garcia is ours. So I'm gonna hand the files down to you if you wanna.
Okay, certainly, thank you.
Make your notes.
Oh. It'll just take me a minute, Judge, to put them on the computer.
Okay, we got time. Thank you.
Still with that, Mr. Glacier.
Yeah, I think he said he was heading over.
He seemed excited about it.
Well, all set, Judge.
Rhonda, are you done with Mr. Austin?
Yes, Your Honor.
I'm sorry, I didn't realize you. We're done. We have another pickup too that I wasn't aware of, so we'll figure that one out in a minute. All right, Mr. Austin. Nolan. All right, so Ms. Underwood, you have had an opportunity now to speak with Mr. Austin.
Yeah, Your Honor. Mr. Austin apparently has another case that, which is the genesis of this violation. Mr. Austin, I gather, is still in warrant status on that and has not turned himself in.
I was unaware that I was supposed to turn myself in for this case to proceed.
So I guess we need to adjourn this, Your Honor, for Mr. Austin to turn himself in on the case from St. Joe County and
which I plan on doing.
Well, I have a warrant on Mr. Austin, so we do have an active warrant for Mr. Austin here as well. It is a non-technical violation, Ms. Underwood.
Right.
Why do I have a warrant there now?
I don't
the one I show is.
All right, I can't hear everybody talking at the same time, so let Ms. Underwood talk. It's okay.
The one I show is for police contact and alcohol, correct?
Yes.
Hold
on, Mr. Austin. Let Ms. Underwood talk real quick.
And that is a case that I understand is in St. Joe County and needs to be addressed.
Okay, so I guess he should go turn himself into St. Joe County.
He needs to do that.
And then we'll get him from St. Joe County because we'll have a holder on him.
Can I speak?
Who, Tom?
Yes. So he turned himself in February 18th to this court.
Yeah.
Or I'm sorry, February 18th. And we arraigned him. And he pled guilty and we pushed the trial date out to today. So
So I released him on bond then.
Yes.
Okay, so I don't have a warrant outstanding on him. Okay.
Correct. Yeah.
I have his file. I just have paperwork.
Right, and we pushed it out so he could go take care of the stuff over in the other county. So wherever the miscommunication is, I don't know, but he needs to go do that.
And I will do that, and I'm gonna go do that.
Okay, so if it's an OWI, they're probably not going to keep it locked up. So, Mr. Austin,
I got the money for bond. I'm sorry for cutting you off.
No, it's okay.
I've been working 14 hours a day, so I got the money.
So what I'm just saying to you, Mr. Austin, the sooner you go take care of it, the less likely they're going to keep you in jail. Do you understand that?
Yeah, and I'm sorry that
All right, so Mr. Austin, I'm going to set this over to May 14, and I want you, like in the next week or so, to go take care of that case in St. Joe County.
Okay, and I will.
All right, and then we'll see you back at May 14 at 8:30 in the morning. Is that all right with you, Rhonda?
That's fine, thank you.
And we'll continue your bond. So, all right, Mr. Austin. So we'll see you back on May 14 at 8:30.
8:30,
but go take care of that warrant. All right.
I definitely will.
Okay. Thank you.
Yep.
All right. You are Mr. Nolan. All right. So Miss Underwood, Mr. Nolan would like court-appointed counsel. So I'm going to put you guys in a breakout room, and then I have another pickup on a Ricardo Garcia. So we'll take him next. Okay.
Thank you.
Good. Thank you, John.
Thank you.
You want to put me in? You want to put me in that breakout room also? Just and then I can even with Mr. Nolan and Miss Underwood.
Okay.
Just so I can update her.
Okay.
Yeah, Britt.
Hey, this is Judge Anslone. I guess I do now have Ricardo Garcia. So, they just reassigned it to me. So,
Ready for him?
yeah, I'm ready for him.
Okay.
Thank you. Bye. Remember him even showing up at recovery court? He's never been to a recovery court, has he? I don't think so.
He moves off the money.
Yeah, oh, it's because he just never showed up. I know, well. Becky, it says he needs prints. There's a posted, I mean, he was sentenced, so I'm assuming he had prints done.
On which file?
On 21-20525. They don't write in the file like you do because you're so awesomely organized, but there's a post-it that says need prints.
Yeah, I don't see prints in the system either.
How did they sentence him then?
Not sure.
Me neither. We need to look into that. Are there prints on his other file, 21-20575 FC? Okay, so I've got Mr. Glazier.
No.
Mr. Glazier is here on, all right, so is it Bonica? Okay, this is in the matter of the people of the state of Michigan versus Michael Timothy Bonica, file number 25-22139FH. I have John Glazier appearing on behalf of Mr. Bonica. And I have Isaac Sneed appearing on behalf of the people. This is the date and time set for pretrial as well as maybe bond hearing. Let's see here, Mr. All right, Mr. Glazier. Oh, it's pretrial. So are you ready to proceed?
I am. Yeah, my client would like a copy of this letter for court.
I don't know what letter it is.
It's a letter to me from Allison. He wants it for his.
Okay, all right, Ms. Adams. Can we get a copy of something from Mr. Bonica? All right, so we will do that. So, Mr. Glazier, with regard to the pretrial today, it's the one right in front of Mr. Glazier. I think it's two-sided. How do you want to proceed today with Mr. Bonica?
Your Honor, he's going to plead guilty to counts 1, 2, and 4, with the understanding that counts 3 and 5 would be dismissed. There is no habitual in this case. There's a killaboo that minimum sentence will be 5 years.
All right, so he's going to plead guilty to count 1, 2, and 4, right?
That's correct.
And what was the killaboo to not to exceed the guidelines and a 5-year minimum?
Yes.
And then I see that there will be no federal charges pursued. Is that part of the agreement?
In fact, that's the copy of the letter that we're getting is from the federal.
I think that's
prosecutor saying that he does that.
All right, and Mr. Glazier, it seems like there's a little frog in your throat a little bit. So if you can move that microphone a little bit closer and maybe speak a little bit louder. So Mr. Sneed is going to plead guilty to count 1, 2, and 4. Count 3 and 5 will be dismissed. There is a killaboo agreement that he will serve a minimum of 60 months with the Michigan Department of Corrections to whatever the max is. I think you guys killabooed to not exceed the guidelines, and you calculate the guidelines to be 36 to 60. And there is an email that Mr. Bonica has been provided a copy of from the federal prosecutor saying that no federal charges will be pursued. So Mr. Sneed, is that a correct recitation of the plea agreement?
Yes, it is, Your Honor, but I do have a portion of the written plea agreement that I'd like to place on the record, if I may.
Sure.
Just that both parties have the understanding that the United States Attorney's Office has agreed not to pursue federal prosecution for any of the underlying conduct described in the police report number in this matter, being Tecumseh Police Department report number 243257, as long as defendant pleads guilty to counts 1, 2, and 4 and receives a minimum sentence of at least 5 years in the Michigan Department of Corrections. If the United States Attorney's Office does not follow this agreement, then this plea would be invalidated. And that's all I have to add. Thank you.
So he would have a right to withdraw his plea if the attorney or the federal prosecutor does not honor the agreement.
I understand.
In effect.
Okay. Yeah, thank you, Mr. Sneed. All right, so Mr. Bonica, you want to raise your right hand for me? And Mr. Bonica, make sure you speak loudly for me, okay? Because we have to record this for appeal purposes, okay?
All right.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, and Mr. Bonica, you've heard the statement of myself, your attorney, the prosecuting attorney. Is it your intention today to plead guilty to count 1, child sexually abusive material, aggravated possession, which carries a maximum penalty of up to 10 years in prison and or a $50,000 fine? And this is a tier 1 offense under the Sex Offender Registration Act. So that's mandatory SOAR registration for life. Is that correct, Mr. Glazier?
I believe so.
All right. And is it your intent to plead guilty to that count?
Yes, Your Honor.
And then is it your intention to plead guilty to count 2, child sexually abusive material, aggravated possession? Again, it's a tier 1 offense requiring lifetime registration under the Sex Offender Registration Act. Carries a maximum penalty of up to 10 years in prison and or a $50,000 fine. So is that your intention to plead guilty to that one as well?
Yes, Your Honor.
Okay, and then count 3 would be dismissed. So Mr. Bonica, is it your then intention to plead guilty to count 4, children accosting for immoral purposes, which is a 4-year felony, carries up to a $4,000 fine, which is a tier 2 offense under the Sex Offender Registration Act, which is, I believe, 25 years. Mr. Sneed, he has no prior CSC convictions or anything that would affect the Sex Offender Registration Act?
Well, that's my understanding, Your Honor.
Okay, so I just want to make sure I'm right on this. Okay. So 25 years. So tier 1, I guess, is, if I'm right on this, it would be he must register in person once a year for 15 years and be listed in a public registry. So, so Mr. Bonica, is it your intention then to plead guilty to all 3 of those?
Yes, Your Honor.
All right. Are you satisfied with Mr. Glazier as your attorney and the advice that he's given you?
Yes, Your Honor.
All right. Other than the plea agreement, which was pretty comprehensive, that was placed on the record, neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Glazier?
Yes, it is.
Mr. Sneed?
Yes, Your Honor.
And Mr. Bonica?
Yes, ma'am.
All right. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at trial and to ask those witnesses questions. You have the right to have the court order any witnesses you might have to appear at your trial. The defense to appear at your trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand if your pleas are accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. And you understand you're going to be required to register under the Michigan Sex Offender Registration Act?
Yes, ma'am.
Do you have any questions about the rights that I've given to you?
No.
All right, how do you wish to plead to the charge that on or about September 25 of 2024 in the city of Tecumseh in the county of Lenawee, that you did commit the offense of child sexually abusive material aggravated possession, guilty or not guilty?
Guilty.
And how do you wish to plead to the charge under count 2 that on September 25 of 2024 in the city of Tecumseh in the county of Lenawee that you did commit the offense listed under count 2, child sexually abusive material aggravated possession, guilty or not guilty?
Guilty.
All right, and then Mr. Bonica, how do you wish to plead to the charge that on September 25 of 2024 in the city of Tecumseh in the county of Lenawee that you did commit the offense listed under count 4, children accosting for immoral purposes, guilty or not guilty?
Guilty.
All right. Has anyone made any threats or promises to induce you to plead guilty to these charges other than what was placed on the record?
No, ma'am.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given? You need more, speak up, Mrs. Spade.
I asked him to speak up.
Okay. Do you understand, let me see. Do you understand if I accept this plea, you'll be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Glazier?
No, Your Honor.
Mr. Sneed?
No, Your Honor.
Other than the plea agreement, has your attorney promised you any particular sentence or estimated what your sentence will be?
No, ma'am.
All right, is it your own choice to plead guilty?
Yes.
All right, so Mr. Bonica, on September 25 of 2024, were you in the city of Tecumseh in the county of Lenawee?
Yes, ma'am.
All right, were you at your house?
Yes, ma'am.
Okay, and did you possess or have in your possession sexually abusive material involving sadomasochistic abuse or bestiality?
Yes, ma'am.
Okay, did you know that it was, you possessed it?
Yes, ma'am.
Okay, and, okay. Did you, okay, so that's count 1. Are you satisfied on count 1, Mr. Sneed?
Yes, Your Honor.
All right, so for count 2, the child sexually abusive material aggravated possession, did you have in your possession child sexually abusive material involving a prepubescent child?
Yes, ma'am.
And you knew you had that in your possession?
Yes, ma'am.
All right, and then for count 4, did you solicit an individual that you believe to be less than 16 years of age with the intent to have that individual commit an immoral act or submit to sexual intercourse or some act of gross indecency?
Yes, ma'am.
Okay, were you texting or Instagramming or Snapchatting? What were you doing?
The Telegram app.
Telegram app?
It's like Snapchat.
Okay, and so you thought that individual was under the age of 16?
Yes, ma'am.
And it was your intention to induce them to have sex with you?
I guess so, yeah. I mean, it was texting and talk, but it was sexual in nature, yes.
Okay, all right, Mr. Sneed, any other questions on that count?
No, thank you.
Has the court complied with MCR 6.302 B, C, and D? Mr. Glazier?
Yes, sure.
Mr. Sneed?
Yes, it has, Your Honor. Thank you.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the plea or a possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of them. But of course, barring any issues with the federal prosecutor, the court is bound by any Killebrew agreement at this time struck between the people and Mr. Bonica's counsel. So I'm going to refer this matter to the probation department for a pre-sentence investigation. I will set it for sentencing on May 29 of 2025 at 8:15 in the morning. Mr. Bonica, you can come in person or you can appear via Zoom. How would you like to appear?
Zoom will be fine.
Okay, that'll be Zoom. Mr. Bonica, someone from the Michigan Department of Corrections, probably an individual named Chris Jones, is going to come over and meet with you at the jail. Be truthful with them about your background, the events that occurred. He'll prepare a pre-sentence report. Mr. Glazier will review that with you in advance. And then we will see you back on May 29 of 2025 at 8:15 in the morning. All right. All right. Thank you.
Thank you.
Thank you.
Yeah.
Okay, so. Great, thank you, Mr. Glazier.
Thank you. Thank you.
All right. All right, so Ms. Underwood, you've had a chance to speak with Mr. Nolan. How would you like to proceed with Mr. Nolan?
Your Honor, Mr. Nolan would like to plead guilty to the violation.
All right, so Mr. Nolan, you want to raise your right hand?
Yes, ma'am.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, can, Mr. Nolan, we were previously, you put your hand down. We were previously here, you had asked for court-appointed counsel. We've appointed Ms. Underwood to represent you. You've had ample time to speak with Ms. Underwood?
Yes, I have.
Are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes, I am.
All right, now, Mr. Nolan, do you understand that you have a right to contest this violation of probation charge?
Yes.
You understand you have a right to have a hearing on it?
Yes.
Do you understand throughout the hearing you would be presumed innocent until your guilt is proven by a preponderance of the evidence? Do you understand that?
Yes.
You have, let's see, you have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions. You may ask them yourself, to have me order any witnesses you might have to appear at that trial. I'm so sorry. Do you understand all of that?
Yes, I do.
You do not have to testify at your trial. No one can say anything about you not testifying or hold it against you in any way. On the other hand, do you understand that you have a right to testify at your trial if you want to testify?
Yes, I understand.
Okay. How do you plead to the charge that you violated the terms of your probations on both files, and that you were ordered not to use any illegal controlled substances, and on April 7 of 25, you tested positive for marijuana and cocaine and admitted to the use of the same? So how do you plead to that charge? Guilty or not guilty on each file?
Guilty.
All right, do you understand by pleading guilty, you'll be giving up your right to a trial? Is that I've already explained to you?
Yes, ma'am.
Has anything been promised to you to get you to plead guilty?
No.
Has anyone threatened you in any way to get you to plead guilty?
No.
If I accept this plea, you'll be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes, I do.
Is it your own choice to plead guilty?
Yes, it is.
All right, so Mr. Nolan, on both of these files, you were placed on probation and then on November 8th of 24, you were ordered not to use any illegal controlled substances. Is that correct?
Yes, it is.
And then on April 7 of 25, was it a report day and you tested positive for marijuana and cocaine?
On colors.
All colors, okay. And you tested positive for marijuana and cocaine, is that correct?
Yes, it is.
And you did admit to using it, is that correct?
Yes, I did.
Accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. My next date available for sentencing is April 25. Are you available that day, Miss Underwood?
That's fine, Your Honor.
All right, so I'm going to set you for sentencing on April 25 at 8:15 in the morning, Mr. Nolan. Your probation officer will meet with you. They'll do a pre-sentence report, and then we'll see you back on that day for sentencing. Miss Underwood will review that with you probably the day before sentencing. Mr. Moore, is this your file?
Sarah Teskey's, but correct, I was helping her with that.
I didn't know if you need to talk to Mr. Nolan.
I believe she will probably talk to him.
All right, so Mr. Nolan, you're all set. Thank you.
Thank you.
Yeah.
Judge,
Wait.
can we do that at 9:30?
Yep, we're gonna do April. Well, if I read her notes, I would have known. It's April 25th at 9:30. Are you available at 9:30, Rhonda Underwood?
I guess, Your Honor, yeah.
Okay, I'm sorry, Mr. Nolan. So 9:30 a.m. Do you want to be here in person or via Zoom, Mr. Nolan?
Zoom is fine.
Okay. All right. Thanks, Mr. Nolan. We'll see you back.
Thank you.
All right. Mr. Nolan. All right. This is in the matter of the people of the state of Michigan versus Jonathan Gonzalez Rodriguez. We have, wait, what's your name?
Ricardo Garcia.
Oh, I didn't think you were him. All right, so this is in the matter of the people of the state of Michigan versus Ricardo Anthony Garcia. File number 21-20525FH and 21-20575FC. So, Mr. Garcia, we are here on a request and warrant for probation violation that was filed or signed by this court on April 15th of 2025 for both files. And Mr. Garcia, it is alleged that you committed the following, and this is a technical violation. On February 3rd of 2022, you were ordered to report to the probation department any change of address within 24 hours. It's alleged that you failed to do that and you changed your address on March 11 without permission of the field agent. The second one is a non-technical violation. On February 3rd of 2022, you failed to, let's see.
Ma'am, I was in prison at that time.
Yeah, hold on. Count three, I'm trying to read this because it says on February 3rd of 22, probably you were ordered to report to the probation department, and then you failed to report on March 19 of 2025. So anyway, tell me, when were you in prison, Mr. Garcia?
Okay, I got out of prison in November of 2024. I was in prison for 3.5 years from 2021 August to November 2024.
When did you get out of prison again? November of 24?
Yes, ma'am.
Okay. Did you report to the probation department?
Yeah, when I got out of prison, I reported everything.
Okay. So I'm struggling, Ms. Walsh, to read the felony warrant. I guess he was placed on probation in 22. One of the allegations is he moved on March 11 of 25 without permission of the agent. It says February 30 failed to report to the probation. I think that meant he was supposed to be ordered to, and that he failed to report on March 19th of 25. So I think the allegations are both Miss Underwood when I read it, that in March of 2025, he violated the terms of probation. So, Mr. Garcia, you have a right to have an attorney represent you at this and all subsequent hearings. Can't afford to hire one. We will appoint you one at public expense. We have Miss Underwood here. Would you like an opportunity to speak with her?
Yes, ma'am, please.
Okay. All right. We will appoint counsel. Miss Underwood, I am going to close this breakout room. So I'm going to put you two together. Miss Underwood. All right. Go ahead and join that breakout room. Mr. Sneed, I think we have, let's see. Let's see. A pretrial 11 on Gonzalez. So look, Gonzalez Rodriguez. So you got about 40 minutes, I think, Mr. Sneed, you're muted.
I'll log back in then, Judge. Thanks for the heads up.
Okay, just letting you know. Thanks. We went to Veronica's yesterday, and Sierra got a Trizley J cake to take to a board meeting. Can't wait to see how it was.
Yeah, that's cool.
I wonder if they get all their pastries, the Mexican pastries from Detroit.
I think so. I think that's where they go, but I'm not sure.
It looked really good.
What's that?
It looked good.
Did it? Good.
They have really good barbacoa there on Saturday mornings.
Yes, they do. Yep, they do.
Well. All right, Ms. Underwood, let me close that breakout room. All right, Ms. Underwood, we are back with Mr. Garcia. So how would you like to proceed today on behalf of Mr. Garcia?
Your Honor, I would ask the court to enter a not guilty plea on Mr. Garcia's behalf and set this matter. Your Honor, Mr. Garcia has a bond hearing in district court at 1 o'clock on new charges. So, and a probable cause scheduled for the 22nd. So I believe next week would be appropriate, Your Honor, to see what's happening there.
What are his new charges?
I can tell you, ma'am. It's larceny in the building, 2 counts of R&O, and a retail fraud.
Okay. All right, so you want me to set this out past the 22nd, Ms. Underwood?
Yes, Your Honor.
All right, so I'm gonna set this out to April 30th. You said April 22nd or May 22nd?
Well, Your Honor, I don't want it set out that long.
When is, you said April 22nd is his court date?
April 22nd, yeah.
All right, I can do April 23rd, but I'm really busy that day. I can do April 30th.
Okay, why don't we try the 23rd?
Okay. all right, we'll set it over to April 23rd at 8:30 in the morning. Obviously, his new charges could be a pending violation too. So, all right, so honor plea of not guilty on your behalf, Mr. Garcia. And then we will see you back on April 23rd at 8:30 in the morning. But just to give you a heads up, those new charges could result as well and probably will in a new violation, all right?
Yes, ma'am.
All right, thank you, Mr. Garcia. All right, Ms. Underwood, your next one is the guy here from. All right, Ms. Underwood, we don't have MDOC yet. He's supposed to be in person, so I will see you at 11.
Thank you, Your Honor.
All right, thank you. All right. All right, I'm gonna take a recess. Ugh.
Did we cover Andrew Wright?
Let me see.
He's on the
Wright
last.
waived arraignment. He waived arraignment.
Oh. And one more. Nathaniel Garcia.
He waived arraignment, and so did Chelsea Leininger.
Okay, so just one more at 11.
Yep, that's it.
Okay, thank you.
Thank you. That was a whirlwind of a rain.
Hello, sir, may I help you?
I was supposed to meet my lawyer here, Mr. Navarro.
Who are you, sir?
Dwayne Dunning.
Dwayne what?
Dunning.
Dunning?
D-U-N-N-I-N-G.
Okay, let me just look up real quick, okay? It was Mr. Glazier, sir? Mr. Glazier? Is that who you're supposed to meet? Who'd you say?
Malero.
Oh, Mr. Malero. You said your first, it's D-U-N-N-I-N-G, and your first name is Dwayne?
Yeah. E-W-A-I-N-E. I just talked to him 5 minutes ago.
Well, maybe he's
Thought
on
he'd be
his,
waiting for me up here, but I guess not.
he may be on his way here, sir, I don't know.
Judge Anslow. Just already here.
I'm checking.
Two different judge.
This is Judge Ansell's. I'm showing that you're supposed to be in Judge Olsaver's, actually. You're welcome. Pardon?
Thank you.
You're welcome.
Brenda's down there talking to him.
Oh, is she okay?
Thanks. Thank you. All right, Mr. Sneed, Rhonda is down in lockup, meeting with her client.
Thanks, Judge.
Yep, and just be a minute.
There she is.
And there she is. So her client should be following her down the hall. They're bringing your client down.
He's got,
He's fine.
he says he's gonna plead.
All right, I'm nice.
This is one count one. As charged, no subs.
No subs?
No subs.
So there's no sub on this plea, Mr. Sneed?
Correct, Your Honor.
Okay. All right.
And under the guidelines, Your Honor.
Not a problem. All right, let's get him down here. And we'll. He can't take off his hat, but we can help him. There we go. All right, so this is in the matter of the people of the state of Michigan versus Jonathan Gonzalez Rodriguez, file number 2023-21565 FH. So Mr. Gonzalez Rodriguez, step up a little bit for me. So we had you brought in person last time, but we had some difficulty hearing you from MDOC, and then also Miss Underwood wanted to meet with you. So I have Rhonda Underwood appearing on behalf of Mr. Gonzalez Rodriguez. I have Isaac Sneed appearing via Zoom from the Lenawee County Prosecutor's Office. So Mr. Gonzalez Rodriguez, have you had a chance to speak with your attorney this morning?
Yes, ma'am.
All right, thank you. Miss Underwood, how would you like to proceed today?
Your Honor, Mr. Gonzalez Rodriguez have had a lengthy discussion on this issue. Mr. Gonzalez Rodriguez understands that if he went to trial, he would go to trial on what would be a felony with a life tail because those habituals are there. He further understands the plea bargain offer is reduced, plead to count one as charged, no supplements. Count two would be dismissed, and we would also be asking the court for a COPS to the low end of the guidelines. Under those circumstances, Mr. Gonzalez very wisely has indicated he wishes to accept that plea offer at this point.
So Mr. Gonzalez, the plea has changed. It's actually gotten better from my notes. So the plea offer is to plead to count one, assault of a prison employee that is a 5-year felony. You can carry up to a $2,500 fine, but I don't assess fines for MDOC inmates. Do you understand that?
No.
Now, Mr. Gonzalez Rodriguez, this does stack on any sentence you're currently serving now. Do you understand that?
No.
All right.
Could you speak up, please?
Could you speak up just a little bit for us? Okay, good. And do you understand that the court will sentence you to the low end of the guidelines?
No.
Okay. All right. And then the count two and the habitual offender fourth offense notice, which would have made it life, will be dismissed. Okay. Are you set? And is it your intention then to plead guilty to count one, assault of a prison employee?
Yes, ma'am.
All right. Are you satisfied with Miss Underwood as your attorney and the advice that she has given you?
Yes, ma'am.
All right. Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence. Is that correct, Miss Underwood?
That's correct, Your Honor.
And Mr. Sneed?
That's correct, Your Honor. Thank you.
And as far as you're aware, is that true, sir?
Yes, ma'am.
Okay. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have a right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Sir, do you understand if your plea is accepted, you may be giving up the right to any appeal issues that would otherwise be appealable had you had a trial and been convicted? Do you understand that?
No.
Do you understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right? Do you understand that?
No.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
Amen.
So, sir, how do you plead to the charge that on or about August 2nd of 2023 in Madison Township in the county of Lenawee, I'm going to guess at the Gus Harrison facility, that you did commit the offense of count 1, assault of a prison employee? Guilty or not guilty?
Guilty.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
Amen.
All right. Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that? Do you understand that? Okay.
We're
Is
not
the-
picking him up, Judge.
All right. I'm so sorry. You're kind of soft-spoken. Attorneys are never soft-spoken, so I just need to make sure you speak up loud enough we can hear you, okay?
Yes, ma'am.
All right, perfect. Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Underwood?
No, Your Honor.
Mr. Sneed?
No, Your Honor.
Right, has your attorney, well, yeah, we already have a plea agreement. All right, so it's your own intention to plead guilty today?
Yes, ma'am.
All right, so Mr. Gonzalez Rodriguez, on August 2nd of 2023, were you at the Gus Harrison facility?
No.
Would you agree that's located in Madison Township in the county of Lenawee?
Yes, ma'am.
Okay, and he was wearing his uniform like these gentlemen today?
Yes, ma'am.
All right, and you knew he was an employee?
Yeah.
Okay, good. And you assaulted him and somehow, how did you assault him?
Punching.
You punched him? Okay. And you were convicted of a crime and lawfully incarcerated at Gus Harrison at the time this happened, correct?
Yes, ma'am.
All right, Mr. Sneed, are you satisfied?
I am, thank you.
All right, has the court complied with MCR 6.302 B, C, and D? Ms. Underwood?
It has.
Mr. Sneed?
Yes.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made a Cobb's agreement regarding the sentence range in this matter. But other than that, there has been no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. Sir, where are you currently?
He's in Ionia.
You're in Ionia? Okay. All right. So, sir, someone from the Michigan Department of Corrections Probation Parole Division is going to get a hold of you. And then they're going to ask you about your background, the events that occurred. They're going to prepare a pre-sentence report. We'll get a copy to Ms. Underwood. She'll get a copy to you. Ms. Underwood's really good about trying to review things with people in advance, but sometimes, you know, MDOC is a busy place and we can't always get in. So if she's not able to review that with you in advance, she will be able to the morning of sentencing. Do you want to come in person or do you want to appear via Zoom?
Zoom.
Want to do Zoom? Now, we had a hard time hearing you last time when you were on Zoom, and that's why we had you come in person.
You want me to come in person a little better?
Your Honor, I think
I think they placed him in a cage in Ionia.
Yeah, he was at a cage at the back of the room. I couldn't hear him.
Would you rather come in person, Mr. Gonzalez Rodriguez?
Yes, ma'am.
All right, so we're gonna do that in person. Miss Adams, can I set it for like 9 or 9:30 on May 29th?
That is day 2 of a jury trial, but
Did I swear him in, Joanne?
Sorry?
Did I swear him in?
I thought you did.
I don't think I did.
No, I don't. Hold on.
I'm sorry. Can you raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, and that you have told the truth?
Yes, ma'am.
All right, so, sir, under oath, all your answers that you gave me here were true?
Yes, ma'am.
Okay, thank you. What did you say, Miss Adams?
that is day 2 of a jury trial for Mr. Rodney Hill.
All right, I'm gonna set this for sentencing at 9 AM on May 29, because I think Mr. Hill, I don't know, he's been in and out a couple times, so.
And, Your Honor, just for the record, Ionia is one of those places where they will schedule a telephone conference.
Excellent.
So I believe we've done that before and I can review it ahead of time.
Okay. All right, so we will see you back May 29th at 9 AM for sentencing, and then we'll have you brought here. We usually do them at 8, but we'll set it for 9 so you get some more road time. And then we'll see you back on that day, okay? All right, thank you.
See you then.
Bye, safe travels.
So.
Thank you.